Hello, I'm Suzanne James. Welcome to Nightshift, where we talk all things voluntary assisted dying in Australia. We'll be joined today by Steve Walker. Steve is President of Dying with Dignity Western Australia, who has a special interest in both telehealth and also in our main topic of discussion today, which is VAD for dementia. Steve joins us now from Western Australia. Steve Walker, welcome.
Thank you, Suzanne. Thanks very much for including me in this.
How and why did you become involved in voluntary assisted dying advocacy? Tell us about that.
Oh, sure, thanks. I became involved for two reasons. One is that I was a lawyer. I'm now retired, but as a lawyer, I always, I suppose, tended to get involved in human rights and civil liberties issues of various kinds, whether it was the right to protest, um, all sorts of other things, social security cases. I used to do child welfare cases. And it struck me over a long period that it was really quite absurd that the parliaments in this country were unprepared to listen to what was obviously a majority view in the community, that they wanted the right to choose how they would die, even if those circumstances or the rules around it were quite tightly defined. The second way I became involved is actually that my mother was a long-standing member of what was called WAVES, WA Voluntary Euthanasia Society. I used to along to a few meetings with her, and in a sense, I inherited from her the interest in this topic. And so I've been a member of what is now called DWD, for a long time. I've been a committee member probably for about, I'm not really sure, but about 12 or 14 years. And I've been the president now for about 8 years. And that move, I guess, coincided with me becoming at that point semi-retired, so I had a bit more time. And secondly, it coincided pretty much with the large campaign in WA beginning for VAD laws in this state, which was around 2018, 2017, 2018, and of course our law was passed in December 2019 and became effective in July 21. You know, there's a continuing need for attention to the terms of our legislation and improvements for those large categories of people who currently miss out on the choice I've mentioned.
Now, one thing that's become a very vexing issue across the country since VAD became legal here across the various states in the ACT has been the anomaly in the Telehealth Bill. Now, for those that aren't familiar, in 2005 there was a clause put in the Crimes Act which rightly prevented the use of a carriage service to menace or to entice someone to commit suicide. However, since that clause was put in, voluntary assisted dying, which under the state-based legislation is clearly separate and is not considered suicide, it's a medical legal end-of-life option. However, the Commonwealth Code hasn't been updated to reflect that, and that anachronism is causing a lot of grief in that doctors can't use telehealth for e-scripts or for phone calls or for even part of the many required consults to have with patients to get VAD approval. So it was actually Western Australian MP Kate Chaney that put up the Telehealth Amendment Bill a couple of years ago. That was allowed by the government to expire, but on the back of a current push by Go Gentle Australia, she's just reintroduced that bill. So, Steve, you've had a special interest in this and will be well familiar with Kate's bill on this. Why do you think the governments continue to ignore the growing demands for this? And do you have a view on what the blocker is? I mean, everybody wants it, AMA included.
Yes, you're right, everyone does want it, and it's still something of a mystery as to why the federal government continues to block. We do have a long involvement with this issue because it was we who went to see Kate Chaney to ask her whether she'd be prepared to try and do something already at that stage, and that was 2 or 3 years ago. But already at that stage, there appeared to be some sort of blockage within the federal system in the sense that the Standing Committee of Attorneys General, which meets regularly, including the attorneys for all of the states and for the Commonwealth, had this issue on its agenda for some time, and no one could quite see what the delay was about, since all of the state attorneys were pushing for it. Kate acted extraordinarily quickly and effectively in producing a bill within, as I recall, it was about a week. And even though it's a simple measure, it only involves creating an exception to these prohibitions and these offences if the communications in question are done pursuant to a valid and legal BAD scheme. So even though it was a simple issue, she did act really brilliantly. As you know, Suzanne, what happened is that she was allowed to speak very briefly on it in the lower house, only for about 10 minutes. And another Teal member also spoke briefly, but then the federal government effectively killed the bill by not allowing it to be brought up for debate, and then the parliament was prorogued for the next election. Kate had astutely predicted to us that that is what would happen, but she hoped that the Commonwealth Government would a little later take up her idea, present it as its own, get it passed, and claim the kudos, because cynical though that sort of action is, it's what has happened before with federal governments. Um, uh, the reason for that blockage and blocking action by the federal government, and the reason for it not moving in the Standing Committee of Attorneys General, is still not clear, but most people whom you ask about it suggest that it's the Prime Minister personally who's the problem. I would add that I went to see the federal member for Fremantle about this to seek his support behind the scenes. That's Josh Wilson, and he revealed to me he's a strong supporter of VAD, and he said he would do what he could, but apparently he could do nothing, because in the end he simply sent a bland message back to me that the government was still considering it and it was a complex issue.
I've looked at the legislation, I've looked at the Crimes Act, and I've looked at the Telehealth Amendment Bill. I've also looked at the significant blaze of publicity recently put out by Go Gentle Australia around the telehealth issue. And one sentence needs to be inserted in legislation just to fix it in relation to this one set of state-based legislation. It would have to be the simplest legislative fix I've ever seen a government not take for something that's such a big issue across the country. I'd like to
Yeah.
move now on to dementia, which is going to be our key focus of discussion today. This is a very special interest area of yours. You recently authored a paper for the ICEL 5 conference in Brisbane, which for the uninitiated is the International Conference on End of Life Care. In his book, A Completed Life, published posthumously in 2023, Victorian VAD pioneer Dr. Rodney Syme called dementia the worst disease known to man. There's almost universal agreement that the current legal options for dementia patients, including palliative sedation and voluntary refusal of food and fluid, are not enough, and we're seeing a terrible amount of unnecessary suffering in the community because of it. Some people want VAD to expressly include clauses for dementia. Others say it should be done externally as part of an advanced care directive. Now, you're very much in the category that the VAD legislation itself should include provision for dementia. I'd like to go through one by one your arguments about that, please. Your first was getting rid of the 6 to 12 month till death timeframes as they have in the ACT. How does that within the VAD legislation assist with dementia diagnosis inclusion?
I think that step, the removal of the time to death requirement, would be a necessary step, but not an adequate solution to the problem. So it's one of several changes that need to be made to allow people who choose voluntary assisted dying to exercise that right after they lose capacity. But it's not enough by itself. Um, as you know, the ACT is one jurisdiction in Australia that has taken a step forward in regard to the time to death requirement. In every other jurisdiction besides the ACT that has passed VAD legislation, the requirement is that a person be assessed as having um, uh, 6 months or 12 months to death, 12 months in the case of a neurodegenerative condition. Queensland's a little bit ahead of the others in that it applied the 12-month rule to everybody, and Victoria is just now taking, or has just now taken the step, a similar step of having the 12-month rule apply to everybody. That is very much a step forward for a number of reasons for people generally. So even if we move away for just one moment from loss of capacity and dementia, it's a step forward because it removes this arbitrary, rigid, and really difficult to apply requirement for medical practitioners to assess how long it is before you may die with a particular condition. Um, the continued application in many states of the 6 or 12 month rule means that there are many people who will continue to suffer unacceptably to them with a serious condition simply because their suffering is going to go on for more than 12 months. And that is an absurd aspect of our VAD laws, which operate still in most parts of Australia. So the ACT has taken that step forward, and I would like to see every other jurisdiction do the same. And it would be one step, but only a first step along the road to allowing access as well to those who suffer from dementia or any other condition that may cause them to lose capacity.
Of course, the primary blocker with dementia being included in VAD is exactly that. You have to, even if you're already approved for VAD, still maintain full decision-making capacity right up until the time you take the medication, which brings us to your second suggestion that they should consider amending definition of advanced in the case of dementia, because by default, if you have dementia by the time your condition's advanced, you've already lost decision-making capacity. Talk us through that one.
Yes, thanks, Suzanne. Yes, there are two essential reasons why someone suffering from dementia is essentially never going to meet the VAD criteria as they are at the moment. And one is the first is what you've just mentioned. Under the legislation that applies everywhere, including in the ACT, one of the criteria is that your condition must be advanced, quote unquote. The other condition that bears down on this is that a person must have and retain the capacity, in other words, have enduring capacity to make a decision and request for VAD right up until the moment of their assisted death. Now, clearly, a person with dementia is facing a condition with a certain time frame. It's impossible to be precise how long it will take to cause death, and it's difficult to say exactly when in anyone's assessment it would become advanced. But the fact is that by the time your dementia is advanced on anyone's understanding of that word, it will mean that you've lost the necessary capacity to make a request for VAD. By the time your dementia is advanced, and I quote some studies in my paper about this, it's clear that a person will no longer retain the capacity to, for example, recognise loved ones and carers, often to walk, to dress themselves, and various things of that kind. And it really necessarily follows that by the time their dementia is advanced, they won't have the capacity that our current laws require. Now, I've put forward some suggestions, hoping to stimulate discussion about how we could move this forward. One would be simply to remove the requirement that a condition be advanced in order to qualify. I've said that I suppose that the odds against achieving that will be very high, that parliaments will want to still limit eligible conditions to ensure that the condition in question is moving towards death, if I can put it in that general way. So I've said, look, you could remove the definition, or you could you could define it, and define it perhaps in a stronger and clearer way than the ACT has done. So the ACT, as I've mentioned, still has this requirement that we all have, that the condition be advanced, and sensibly they try to define what that is. It involves a number of elements, but perhaps the most important of those is that the person must be approaching death. And I just think that is perhaps another concept that's really difficult to apply. So I've suggested a couple of different alternatives, centering, for example, on whether the condition is one in which death has become reasonably foreseeable. And I've noted that in Canada, there are some fairly settled definitions of what advance means. I think that reasonably foreseeable is one real possibility because it has a settled meaning in Canada now. And I set out some ways of modifying that as well. I'm interested in particular in trying to define advanced as meaning, at least in part, that the person's that it depends upon the person's view of their suffering, in essence. That if they consider that their current condition is no longer acceptable, then that should be enough, or at least enough to satisfy in part the requirement that it be advanced.
So that was your third point in relation to the definition of suffering, which brings us to your fourth and final point you made in that paper you took to ISL. And this is the one that's been most talked about right now, which is to include a pathway for dementia in a specific advanced care directive, which you can make whilst you still have capacity, whether that's before you get any diagnosis just in case, or you have been diagnosed with a dementia-related diagnosis but still have medical decision-making capacity, which, as you say, quickly deteriorates once the condition is more advanced. Talk us through how that would work as part of existing legislation as opposed to a separate piece of legislation or separate ACD. Steve, how do you see that working?
Now, you mentioned this at the beginning, Suzanne, but I favour a different approach where we don't try to argue for a separate piece of legislation, but rather argue for the amendments or amendments to our current VAD Acts. And I do that for a number of reasons, but one is that I think it's a more feasible way to go in terms of trying to persuade parliamentarians that we should use the vehicle that's now been established and is widely accepted by the community, namely our VAD Acts, which lay out the rules for assisted deaths. As to how I would see it working, and this is the final necessary part of amendments to allow some access by dementia sufferers and others who lose capacity, I would like to see us adopt very much, or at least adapt quite carefully, the model that has been introduced in Quebec, a province of Canada. Now, Canada federally has its own MAID law, medical assistance in dying. Quebec, however, has a separate law, and Quebec's amendments to allow an advanced care directive to be used so that someone who loses capacity can achieve MAID. Those amendments have been in effect from the end of October 2024. So in other words, they've been operating for a little while now. In my paper, I've tried to lay out in detail what are the conditions, if you like, that have to be satisfied in Quebec before a person can use that scheme. And there are many of them. It's a very carefully thought out scheme, but it revolves around a special form of advanced care directive, not just your normal one, that has to be used. And it has to be essentially drawn up in consultation with a medical practitioner. Now, I think that's sensible because, as I see it, it means that the doctor will have input into the way the person is describing their conditions, that in their wish, will be enough to bring about their death once those conditions are reached. The Quebec legislation talks about clinical manifestations, and the person has to set out clearly what are the manifestations, or in other words, symptoms that represent the point at which they want their life to end. The doctor is there, as I see, to make sure that these are understandable and can be applied. Once it's signed, it must be registered in a special registry, and then it can be implemented. Now, importantly, no doctor is required to implement it following the person reaching the described stage of their condition, but they can. And that allows, of course, for the important element of full conscientious objection. Once it appears to a carer, for example, or a relative, that their loved one has perhaps reached the stage that they've described in their advanced care directive, they can bring it, if they want, to the attention of doctors. Two doctors have to do the assessments independently, and if they're satisfied that the conditions or symptoms match those set out in the advanced care directive, it can be implemented. Now, even though that scheme has been in operation now for, I suppose, about a year and a half, it's perhaps difficult to say at this stage how many medical practitioners have been prepared or would be prepared to assist someone in that circumstance. I raise this because we know that in the Netherlands, where you can also access a voluntary assisted death using an advanced care directive, very few doctors these days are prepared to be involved. It may turn out to be similar in Quebec, and I've postulated in my paper that that could be, we could have a similar situation in Australia if we introduce it, but so be it. It's only reasonable that for us to accept that many doctors won't be prepared to go this extra stage of administering a voluntary assisted death to a person who by then has lost the capacity to speak and to indicate that they still want their death to occur. But I think it is a system that can work. It does work, and it's something that could be emulated here. And can I mention that there's also the country of Colombia in South America, which has voluntary assisted deaths for people who have lost capacity. Like in Quebec and like in the Netherlands, the numbers at this stage may be on the small side, but I think it's extremely important that we introduce such a scheme because we know that the great majority of people in our community want such a scheme. They want to know that if and when they are diagnosed with dementia, and of course it's now the leading cause of death in Australia, that they can set out in writing clearly their wish for an assisted death even after they lose capacity. And I just want to highlight the obvious for any critics, and that is that no one will have to use this. It will be an entirely voluntary scheme. Uh, I've mentioned that it has wide support. I think it does. And recent research from Queensland suggests that about 70% of the community favour such a scheme. So we want to see this discussed, carefully analysed, and I would like to see parliaments set up further inquiries to consider schemes like this and how they could operate. And I'm convinced that they can operate safely and fairly.
We're talking about somebody voluntarily, when they still have full capacity, whether it before, during, or after a dementia diagnosis. It's a preemptive voluntary order and something that would, whether or not it was inside VAD legislation or not, would still be subject to multiple medical sign-off, various assessments. The person would have to be deemed to be suffering terribly. All of those things would have to be weighed against their orders in the Advanced Care Directive in order for it to be enacted. I'd just like to finish by talking to you about the two different schools of thought in VAD advocacy about the best way to go about dementia inclusion. Many people believe, as you do, that it could be included in VAD legislation in the ways that you've described. Lots of other people also believe that it's unrealistic to think that that's going to happen with any given time frame. It's going to take forever, could risk damaging the existing working laws that we already have, and we're not going to be able to see it included. What's your response to that?
I think the movement as a whole needs to regroup and press ahead for these reforms. I find myself constantly surprised at the sort of propositions you've set out. I've heard them many times, that it's complex, it's difficult, there won't be public acceptance of a change of this kind. And we need further research and we need to bide our time. I say the opposite. I say that when we look back, the battle to introduce any VAD laws of any kind in this country, that is when we faced what might have been thought to be insuperable hurdles. We, you know, if
Absolutely.
you'd
Yeah.
stopped then and thought about it, you would have thought, well, look, the churches are against us, the AMA is against us, parliamentarians won't accept it. It would involve a sea change in community and legal attitudes. It'll never be allowed. We may as well give up and or wait for another 20 years. Well, we won that battle. And
Yeah.
it turned out that some of our opponents weren't nearly as strong, i.e., the churches, as we thought they were. And wide community support for the move meant that we succeeded. And I say that the changes we're talking about now, which are to refresh our legislation and to make sure certain groups that miss out can be included, I say that that sort of push is less difficult than the one we faced several years ago. It has wide community support, it can work, and it doesn't need further research or waiting time. Instead, it needs people with the determination and the courage to speak up and to point out that we can do it. It's not, the sky isn't going to fall in if we have these sorts of changes. It's been done elsewhere in the world, and perhaps most importantly, the community wants it to happen. So I say to parliamentarians as well as advocates, let's get on with it.
I'd like to finish by asking you about the last 4 years' worth of VAD reviews that you've had in WA. As most people know, voluntary assisted dying legislation and its clinical outcomes are both subject to various level reviews, statutory and clinical, in various ways. So tell us about the key changes that have been recommended by those reviews for the last 4 years in WA and what response you've received, if any, from the current Labor Western Australia government.
Yes, the government appointed VAD board consisting of experts has provided now 4 annual reports containing recommendations to the health minister. Each of those set of recommendations has included recommendations for various amendments to the Act. Not amendments as far reaching as, for example, the ones we're describing, but amendments that, in their view, would be necessary to achieve better operations, a better functioning system. All of them we agree with. None of them is radical. They're all based on common sense and on experience. It has been very disappointing to see that out of 4 annual reports with such recommendations, there's been no positive response from the WA government at all. They haven't sought to implement any of those changes. Now, there was one statutory review, and that report was provided on the last sitting day in 2024 to the WA Upper House or the Lower House by the then Health Minister, and it recommended that no amendments to the scheme were necessary, but instead just set out a series of suggested improvements to administrative and bureaucratic systems. Now, those uh, recommendations it made were all sensible enough, but what's extraordinary is that not only we, DWDWA, but other groups, and also I know the VAD board, made submissions to that review calling for some significant amendments to the Act, in our case, including the sorts of changes we've been speaking about today. And so, although that review got all these submissions, including from its own board, calling for changes to the Act, the review report didn't discuss them, it didn't mention them. It conveyed to the reader, the poor unfortunate reader, that no one had been calling for amendments. It was unfortunately a highly manipulated process in which the terms of reference sought to exclude any changes, any possible amendments to any changes by possible amendments to the Act. So it the result was preordained, and it was really a shocking exercise because it wasn't a real review. For whatever reasons, the WA government won't even has signalled to us through some bureaucrats in recent weeks that they won't even consider any amendments to our Act, no matter how minor, and including amendments recommended by its own board. That is disgraceful, in my opinion, and the Health Minister refuses now even to meet with us. So that is another one of life's mysteries, why it is that these people, previously reformers who were very much behind the introduction of our law, now refuse even to discuss it. But it's not going to stand in our way. We're going to proceed with our advocacy, and we will continue to call for a new parliamentary inquiry in line with community demands and expectations.
Yeah, I think it's a perfect example of what happens when a government wins in a landslide, which they did in WA, and
Yep,
subsequently have no real effective opposition. They can pretty much do whatever they want, and obviously VAD is at the top of their lollipop list.
correct.
Look, it's been great to talk to you today, Steve. An absolute pleasure. Thanks so much for joining us and taking us through your views on that.
Thank you, Suzanne. I'm grateful for the opportunity to talk with you. These are important issues, and it's great to ventilate them and see what further discussion and what results indeed will come out of these discussions.
Thank you so much, Steve Walker, I'm with Dignity President from Western Australia. You've been listening to Suzanne Jones from Nightshift. Thank you for joining us.